All right, I guess we can get started. Thanks everybody for coming on today. Hopefully we have a good conversation with you and amongst you. Want to say that Brad Banasic, our legal counsel, is here, and Brenda Pilgrim, our assistant director for government relations. So people that actually know things are on the call, not just me, and they'll be able to share things with you as we go through this. And I'm going to hit a couple of things like I always do at the beginning of this to talk about, and then maybe ask a couple questions to get feedback from you. It seems like right now that with everything happening, particularly in DC, Brad's getting a lot of questions, so you might have some that you'd like to shoot his way. I'm actually going to start though with just a kind of a reminder announcement. Spring Institute on the island. We weren't sure how it would be received. It's being received super well right now. I think we have over 120 or over 130 registered for that. So people like that we're going back up to the island. I will tell you, we've went through two housing blocks at two different locations that are now full. Whitney is working to continue to put contact information for other lodging places on there. Clearly, we have capacity for the event as far as classes and the 1 day of learning. And there are, yes, Jill, the housing blocks were gone. And unlike sometimes we see that with the annual conference, we'll get secretaries from your districts that will call and book 7 rooms and wait to see how many board members. We don't think that that was the case in this one. I think it is just really a lot of registrants. And, you know, we had to be careful not having done an event on the island in some time. We did not want to, we booked a decent amount, but we didn't want to book so many and find out, oh, early in May and Mackinac Island isn't a time that you all want to be there and get stuck with that, all of those rooms. And being from the UP, I mean, I appreciate everybody attending, but we might have 4 inches of snow that weekend. Don't know. Let's hope not. But I wanted to mention it so that like you can get on. Larissa just posted again the link. There is still lodging. It likely just won't be at Mission Point. But if you're on the island, everybody tends to like walking around anyways, and hopefully the weather will cooperate. I want to get in. I mentioned what's happening at the federal level. You received, if we go back maybe a couple of weeks, you received an email from me that was about what everybody is referring to, the Dear Colleague letter, and then a response from the state superintendent here in Michigan. And then really within a few days, we saw an FAQ come out from the U.S. Department of Education. And so we made the decision, we sent you a follow-up email. We have now created a page on our website. If you go to our main page, you see there's a banner across the top that now will house all of the pertinent executive orders, Dear Colleague letters, responses from our Department of Education. Thank you for putting that up, Larissa. It didn't make sense for us to continue sending you emails once a week or 2 or 3 times a week to keep you up to date. It was easier to create a place that you could go and check whenever you want to. So that web page is up and running, because for us at MASB, we have to figure out how are we a resource to you, and how do we provide you the information that you need. You're not likely going to see something that says MASB says you should do this. Partly because we do believe in local decision making and local authority of you as a local board. So we want to provide you all of the information that's out there. And what I think about from a board perspective, as some of this comes out, and of course we're talking to board members and superintendents that are calling Brad more than anybody, but I've done some too. And what should we be doing? What does this order mean? And I would say what all of the orders should do for a district is open up a conversation. I don't think that they're definitely not succinct. They're all pretty long. Clarity can be a problem. There's questions of legality relating to whether there's executive authority or not to do that. And so what it should prompt is a conversation between the board and the superintendent and your local legal counsel or retainer law firm saying, how do we interpret this? What do we, if we think there's anything that we should be doing, what should we be doing as a district? And you may make a decision that everything you're doing in your district is perfectly fine. And you might make a decision that, oh, we're going to make a decision to rename things, pull back on some programs. Like, it is kind of an open space for the districts to make that decision. Brad has said this in some presentations I've seen. I've said it to other people. I do think after the Dear Colleague letter, there was a lot of reaction where very quickly people wanted to, like, oh, we have to take action. And within a week of that, we had an FAQ come out of the U.S. Department of Education that really shed a lot of clarification and light on the initial Dear Colleague letter. And it is, I think, really showed that Dear Colleague letter was more targeted at higher education than it was at K-12, and that the space that K-12 has to deal with, in this case, with the Dear Colleague letter, a lot related to DEI, that there's still a tremendous amount of wiggle room at the local district level once you consider impact, or therefore negative impact, on groups of kids, which there typically is not in the DEI program. So it should be opening up a conversation. I think the U.S. Department of Ed has now launched their portal for parent complaints. I know that makes a lot of districts nervous. And I would say that, if you go through the process where you have those conversations and you decide that you're doing something and you believe it's the right thing, it's never going to stop people, just like we saw during COVID. Like, you're not going to stop people from being unhappy. If you have somebody that has an axe to grind with your district, no matter what you do, they might file a complaint. And so I think you have to take that with what it is. I think you have to be responsive to your local parents. Of course, that portal doesn't mean that the person that issues a complaint has to be from your district or live in your district or have a kid in your district. You could have somebody writing a complaint from Washington, D.C. about something in your district. So I think you have to think about your communities and don't get too panicked into doing things out of fear. I think that's a thing that you should take kind of as a reminder as we look at this. And MASB did join with MASA, the MEA, the Federation of Teachers, and a couple of other organizations last week on the U.S. Department of Education cuts. 20 or 30 state attorney generals filed suit against the U.S. Department of Education for the cutting of the Department of Ed, particularly as it related to special ed and special ed services. We put out a statement last week with that group of education, with that group I mentioned, saying that we're supportive of that lawsuit moving forward. Department of Ed right now is roughly 4,100 employees. The cuts likely are going down, like they want to cut 2,000 employees out of the U.S. Department of Education. And we have great concerns about how they will be able to functionally serve our state departments and in turn our districts on special ed issues, on Title IX issues, on hopefully not this, but the processing of funds from the U.S. Department of Ed to the states. Like, we understand efficiency and smaller government, but across the board type cuts that don't take into account effectiveness, what the individual programs are doing, could end up impacting kids. And that's at the place that MASB draws the line and says, no, like, this needs to stop. You can go down this road. If you want to go through Congress and make changes to title programs, if you want to do something, that's within the purview of the executive office. But getting rid of the amount of employees they're talking about is just, in our minds, a step too far. We don't think service will be provided at the level that's needed. So we put out the statement on that to kind of let the public know that that's an area that we're unhappy with. We are still waiting to see what's going to happen as it relates to different child nutrition programs and how that might affect school districts. There's just a ton going on in this space. we're going to do our best as we hear about it to share it with you on our website so that you have the information. And I would also encourage you, including today, to share with us. Like if you hear of something and your district does an analysis of what you think an order might mean for you, let us know so that we can have those stories and that we can start building a little bit of that so that we can share that with congressional delegation members from Michigan. And I would encourage you to do the same thing right now. Like that is, if there's anything that's going to impact the kind of breadth of the executive orders, it is getting our congressional delegation to speak up and say, hey, this might be a step too far. I will give an example. It's not education. Some people may question the legitimacy and the order of events, but it is what it is. So I'm going to take it for its face value. And our newest congressman here in Lansing ended up writing a letter to the Department of Veterans Affairs because he is a former veteran himself and arguing that the cuts that were being made in the VA were not acceptable and they really needed to revisit that conversation. And I mean, that's ultimately what we need, right? We need congressional members to speak up and say, nope, I don't support this. We need to have a conversation about it. And I think the only way that they do that is if we, as the education community, lifts up those conversations. So think about that in your space as far as how is it impacting or what do you think the impact will be? Share it with us. Share it with your representation in DC so that they start hearing from you. I think that's important. And I'm going to ask a question now instead of me just talking. Are you hearing from parents, whether that's parents that are saying you need to shut down a DEI program, or if it's special ed parents saying, what are you doing about what's happening in DC? Has it reached a level in any of your districts where parents are starting, or even your staff, your teaching staff, are you starting to hear from people about these topics? And so put it in chat, raise your hand, unmute and talk. I'm just interested in what's happening in the districts. Not much by the sounds of it.
I can chime in. This is Barb Annis from Rochester. Yeah. So we actually have two members that have come forward with a bathroom policy and are claiming that we're not compliant with Title IX because we don't have a specific policy for restrooms that designate that they're for what's deemed biological male and females. So we're seeing that. And we also have parents coming to our board meetings and speaking publicly during public comment that we're not complying with Title IX, and which is false. So yeah, it's definitely being discussed. And I believe our district already has had someone use the new snitch line on the U.S. Department of Education's website to falsely claim that we're not in compliance with the U.S. Department of Ed.
Thanks for that, Barb. Brad, just to kind of follow up on Barb's statement as it relates to, like, we know we had the Title IX regulations under Biden just before the end of his term. That was like struck down as an overstep on executive authority, which I think, if I remember from your last update, rolls us back to where we were at before. So what should a board or a district policy, and I know that Neola has weighed in on this, but what should a district policy be dealing with right now as it comes to bathrooms?
Well, I'm not sure if you need a specific policy on bathrooms. I guess my response to what Barb brought up is that you should have a policy that says we shall not discriminate, and we are going to comply with Title IX and Title VI and the Equal Protection Act and all civil rights laws. That's what you should have at the policy level. You know, how that policy is carried out generally will be with your administration through rules determined by what are the latest interpretations of the law in terms of enforcing those particular civil rights laws. And as you've likely heard, the executive orders, do not carry the force of law. What the executive orders do is they direct the executive agencies on how laws are going to be enforced. Taking Title IX, for example, we know that Title IX is now going to be enforced, prohibiting biological males from participating in female sports. And Title IX is going to be also enforced, prohibiting a biological male from using a female restroom. That's how the executive branch is planning on enforcing Title IX going forward. However, courts could step in and say that's not a correct interpretation of Title IX or the Equal Protection Clause of our Constitution. And we do have precedent in the Sixth Circuit, prior to any of these regulations being issued, that recognizes a transgender student's right to use a restroom of their identified gender. Now, there's some question about how binding that court case is, but most attorneys will point to that case. It's a Sixth Circuit case, is saying that, the way the Sixth Circuit is interpreting Title IX, it would permit a individual who identifies as a different gender to use the restroom of their identified gender. Now, if you do that as a school district, you're likely going to get a complaint, and that could be filed with OCR, and then OCR is going to come in and investigate and determine whether, you're violating Title IX or not. You could enter into a resolution agreement determining whether you're going to keep the status quo or change. And then if you do not enter in that resolution agreement, there could be some penalization relating to funding, and then the case might eventually get to a court. So what I'm saying here, really, it is unsettled to be adopting a policy on the matter one way or the other. So a broad policy indicating we will comply. We're not going to discriminate based upon someone's sex or national origin or race, color, and then it's up to your administration to implement those policies appropriately based upon what the courts are saying.
Brad, because they might ask it, I'll ask it ahead of time. What's the interplay between Michigan civil rights law that specifically protects gender identity and gender expression versus federal law coming in and whether it be Title VI, Title IX? How does that interplay? I mean, I know in Maine they've stood up and said, "Hey, we've got a law that protects. We're not making a change." Athletic Association here in Michigan has said until we get clarification on which one has precedence. Where does that stand here in Michigan?
Yeah, so eventually it may come down to whether the supremacy clause will requires federal law to supersede state law, and again, we don't know if our Elliott Larson Civil Rights Act that identifies gender identity and sexual orientation as protected classes violates Title IX. We know that it doesn't violate Title VII. That's clear. The U.S. Supreme Court in the Bostock case said Title VII, a federal law that prohibits discrimination based on sex. To the next issue will be, is it contrary to Title IX? When that Bostock case was decided, a lot of folks were saying, we're going to apply that analysis to Title IX. So you have some court decisions out there that have adopted the Bostock analysis and applied it to Title IX, which would mean there isn't a conflict between Elliott Larson and Title IX. However, it's made clear by the executive orders and the Dear Colleague letters and guidance from OCR that executive branch isn't adopting the Bostock analysis and applying it to Title IX. So we will see what happens in that Maine case. That's the case to follow. If you're not familiar with that case, in the state of Maine, we had the Department of Education and the Principals Association saying that we're going to follow our state law and we're going to allow athletes to participate in the sport. They're a transgender athlete to participate in the sport that they identify with from a gender perspective. And they received notice of being non-compliant with Title IX. I think 4 days after that notice, they received additional notice that you were in violation of Title IX. Assuming that is going to be challenged by the state of Maine and the Principals Association in Maine, and we'll see where the courts land on that issue. You may be thinking, well, why isn't OCR going after the High School Athletics Association at this point? Because we've all heard that they still have their waiver process allowing a transgender athlete to participate in the sport that they identify with. Well, because High School Athletics Association isn't receiving any federal dollars. The Maine Principals Association does receive federal funds from the Department of Education. So that's how they got brought in to that complaint in Maine. But at this point, and I don't blame the High School Athletic Association for the position that they've taken, because yes, they are clearly subject to Elliott Larson. And someone could bring a claim against their association if they decide that we're going to change course and not have this waiver process. And at this point, it doesn't look like they're going to get involved in a complaint with OCR because they don't receive any federal dollars. I suppose there could be a complaint established with our Department of Education. We'll see what happens there. Just one quick example of how this played out in the past. You may have heard me talk about this at a previous presentation, but if you've been on the board a while, you may remember when you expelled a student, you used to identify that student by name in your board resolution and your meeting minutes. That used to be the common practice at Michigan because that's what was required under our Open Meetings Act, interpreted by our courts. Well, we got a letter from the Federal Department of Education back in the early 2000s saying, Michigan, you're violating FERPA by identifying those expelled students in your meeting minutes and your motions. And if you continue to do that, you're going to lose federal funding. That was an easy fix. It was a clear violation of FERPA. We should not be identifying students. So we put an amendment in OMA saying that you can't have any personally identifiable information of students brought forth in a public meeting or in your meeting minutes, and thus that issue was resolved through that process. So kind of the same thing, going back to, heading 25 years later, and this is what happened in Maine. Doesn't appear that they're going to change their practice. I'm not sure if we're going to receive similar notice at some point, and whether there will attempt to be a change in Michigan to possibly comply with how Title IX is being interpreted by our executive branch.
Thanks, Brad. I'm looking at the comments that people posted, and just on a couple of things that people have said. Clearly, DE&I is the place that you're seeing parent activity based on what you're putting forth. If you haven't had the chance yet to look at the FAQ that came out after the Dear Colleague letter, and I've actually talked to some board members about this, it is written, I think, actually really well. I think it is still subject to the interpretation of a local district in which direction you want to go. But I also think it gave a lot of wiggle room, and it really is about judging the programs that you run in your district and the impact that they have on students. And if they're, and what they really start getting at is whether they have or they can be proven to have a negative impact on a group of students as opposed to just lifting up a group or others. And I think in most cases you'll find DEI programs, I don't care if they're racially based or needs based or whatever, way you look at this, they don't typically have a negative impact on others. They are just meant to create inclusive atmosphere for those that don't feel included and meet them where they're at. So I would really encourage you to look at the FAQ piece of it. I think now whether you're changing anybody's mind, but even sharing that piece with parents, because like everything, right, in the media, social media or otherwise, the headline of the first thing that comes out is what everybody then tees off of and remembers. And the follow-up newspaper article 2 days later, nobody pays attention to. The FAQ in some ways, I think for parents and others, follows that same path. I don't think there's a lot of people who don't even know an FAQ was issued and that it clarified a lot of things regarding DEI programs. And so I think it would be really good for you to take a look at that. I'm sure your superintendent, has already been aware of it and is working through that. But just be aware from that perspective, that's something that can have an impact. Jenna, you made a comment, teachers are afraid of the portal. I was just literally the webinar I had on before this at 11:30. I had both the executive director and the president of the MEA on that same webinar. It was a small group of us meeting with Dr. Rice, and Chandra actually mentioned that very thing. And, it's kind of probably a PTSD coming out of COVID, where we started COVID and schools were loved and teachers were loved for all of the extra effort. And by the end of COVID, depending on where you lived, like they were vilified, and teachers don't want to go back through that process again. Again, that FAQ is pretty clear that as it relates to curriculum, that is the purview of the states and of the local districts. And so, just based on that, teachers should feel, and I know that this is about logic versus fear, which is an emotion, right? But like they should feel comfortable teaching what they're teaching in history and in English classes. But that's hard to say somebody that feels that they're going to end up listed on a report, that's a complaint that's been sent to the U.S. Department of Education. And I think it is a time for, I liked seeing a couple of these where parents are coming in and saying supportive things at board meetings, because we're going to have to lift up teachers and back them up as they're doing things. And they need to know that the board and the administration, if you're standing there and saying the curriculum is our purview, and that you're going to support them in that space. And otherwise, I think fear is going to rule the day, or kind of rule the day, and that can be, I think, problematic for our teachers. And we already have a hard enough time, as you all know, attracting teachers, making people want to go into teaching, or retaining teachers in the field. This is just going to further erode that as they now work in fear and wonder of whether they're going to be on a list somewhere. So the teacher thing is real. I mean, like Terrence from the American Federation of Teachers was on the call today. They're hearing the same kind of thing. And also locally, I mean, a few of you commented, but for a lot of teachers and boards and administrators, they haven't heard much, right? There's some here that you can see where there has been a little bit of activity, but in large part, it's not been lifted up. And in some ways, that's great, right? You keep doing what you're doing. Nobody is saying anything to you, and you run your programs. But it doesn't mean that teachers aren't feeling it at home, even if things aren't coming out for you. So think about that. Think about your teachers. Think about your administrators as they're trying to deal with this. Be transparent as you make decisions. I think that's going to be a big deal. And then, hopefully as a 7-member board, like we always say, even if it's not a unanimous vote, to do whatever it is that you're going to do, stay the course, make changes. Once you've made that decision, try to stick together and be supportive of moving forward until a court makes a decision. All the things that Brad said, right? If a court makes a decision that directs you in a different way, then that's the time that you have to make that change. But up until that time, right now, there's a lot of space for districts to make your own decisions. So let's see. I see Kurt just put up there. Brad, what's Neola true in providing for guidance on language updates if appropriate related to the EOs?
Well, if it hasn't been shared with you, if you're a Neola client, have your superintendent share the letter that Neola, or the memo that Neola sent out in response to the Dear Colleague letter. on the Title VI discrimination and, whether DEI programs could be in violation of Title VI. There's a lengthy analysis from Neola on that, and ultimately Neola says our current policies, as we see them, comply with the law. Because when you look at that Dear Colleague letter, one of the last things that it indicates doing, there's like 3 steps that you should do. It says ensure that we'll put school districts into this phrase, ensure that school district policies and actions comply with existing civil rights laws. So Neola focused on that statement and said, our current policies, as we've presented them to our clients, clearly comply with civil rights laws, based upon the jurisdiction, where those policies reside. So to this point, Neola has not made a conscious decision to change any policies in response, to the executive orders. And now, once courts start issuing decisions on the matter, then there may be some changes. But again, most of your policies at the board level just generally say we are not going to discriminate, under Title IX or under Title VII or under Title VI. Yeah, and if your policies say that, then they don't need to be changed. It's how they're going to be carried out, based upon how after the courts flesh out, all of the contradictions, I guess, between court decisions and these executive orders.
Brad, I don't know if you know the process, and we'll just stick with it. We'll just say Title IX. Because I'm looking at people commenting about the complaint portal that has been created. I don't know what the process is like. Right, let's just say let's go back 2 years and say, if a complaint was filed, what a formal process for starting that. If you were a parent that was making a complaint against a school district on, special ed or whatever it might be, what that process looks like. I know what the process is once they receive it. Mm-hmm. If they create this portal and all of a sudden you get to type in your name and stuff and send it in, does that meet the requirements of beginning a formal complaint? Or is it just like a parent's going to, submit this, but there's going to have to be more follow-up even to make it a formal complaint? I don't know what the requirements are on truly creating a complaint legally.
Right. And I think a lot of that's going to be, dependent upon how the Office of Civil Rights, treats that. I think they will certainly vet those complaints and determine whether there's some legitimacy to them. And, like they've done in the Maine situation and other, states as well, to determine that, yes, Maine is in fact allowing athletes to participate in sports in the gender that they identify with. So clearly, there's some basis to that complaint based upon how the executive branch is currently interpreting Title IX. So yeah, I'm not sure what vetting process they will use, but certainly if they're able to establish, verify that complaint, then it's certainly legitimate and they can start their investigation.
I will say, just for everybody, if you look again, I hate to keep referring to that FAQ, but they do address the issue, not so much of somebody filing a complaint through the portal, but just what the process would look like. Do you risk funding, even though like some of the orders and some of the letters said risk funding? They do clarify and say, much like the process has always been, a complaint will be filed. They will decide whether they're going to investigate it or not. If an investigation ensues and they find the district in a non-compliant situation, they are likely going to try to reach agreement with you on addressing that non-compliance. And if you address the non-compliance, things will move forward and there won't be like any penalty beyond that. That's the way these have always worked in the past. So even in that, they're not going like, oh, we're going to take away, it's questionable whether they can take title funding away, but like they're going to take away different pots of money from you if you're not complying. They lay out that they're going to go through their normal process. I did find it interesting in all of the cuts. I did read, and it's hard to know what's real and what isn't, but that half of the Office of Civil Rights staff would be laid off. On the flip side, they create a portal that's going to create, I would imagine, thousands of complaints into the Office of Civil Rights. And so I'm like, how do you manage the volume of complaints that's going to increase and yet do it with half the staff that you had? So I think that, and maybe they're just directing the staff only to look at those issues, but it does lay out exactly what a complaint process will look like. I've had a few board members very concerned about like the money, like, oh, I don't want to get penalized. And based on that, it does not look like a district will be penalized financially unless you get all the way through the process and decide we disagree with you and like go down that road. So I think for those parents that might come into a board meeting and say, we're going to lose this money, I think you can at least refer to that and say, well, no, they're saying this is the process they'll follow. And at the point, if you are a district that, the Office of Civil Rights says you are in violation, then that you'll, address things accordingly once that happens. But
my thought on this, Don, is that the executive department is really going to cherry pick the ones that are clearly, contrary to the executive orders. So in the main case, I think there's also one in Washington and California. Those states said, we have state laws that we're required to follow. So we are going to allow individuals to participate in sports based upon their identified gender. So there really isn't any investigation required there. In fact, I mentioned with Maine that they received notice of the complaint, and then 4 days after they were found to be in violation. So I think that's how it's going to be early on. The executive branch will look for those situations where an investigation won't be necessary, and then we'll cherry pick from those type of complaints.
Thanks for that clarification. Mark Katz pointed out, and we've had some districts ask this. So he said Royal Oak passed a resolution against the cuts. I mentioned in my intro comments, like getting with your members of Congress. Sometimes I think it's difficult, right? You're an individual board member. Maybe you're not comfortable in that space. I don't think that, I think maybe an easier way is, as a district, pass a resolution opposed to the cuts and forward that to your congressional delegation members. So that's not an individual action. You're not worried. It's just like, hey, we're letting you know that we've taken this position as an entity. And honestly, like, you may not want to wade into DEI waters because of how your district is made up and parents. It, I think, is, and even our decision and related to the cuts as MASB, that is directly related to how your schools are funded, how they are serviced, how your individual kids, like special ed kids, are going to be treated. Like, that's in your purview and legitimate. And I don't think is like partisan in nature to be able to do that and say, we think this is bad for our district and for kids. We oppose the level of cuts that are there. Like, I think that's a pretty easy statement to make without getting a bunch of political backlash as a board. So something to consider just as you do that. And you can see from Mark's comments that, they had people, including teachers, at the board meeting saying thank you as a board for standing up for that. So that is I think, a lower risk space to kind of go down that road. So yes, Jay, your your comments are probably accurate on cherry picking. Questions that you guys have, Brad, subjects that you want to cover, questions that you might have for Brenda on the state level so we could get off of all what's happening in DC, or issues not related to politics, which would be a wonderful divergence right now on things that are just happening in your districts that are coming up, that are just a space that you might need some guidance on, would be helpful. Well, Brad, I'm turning to you then to say if you had some areas that you wanted to touch on.
Should we talk about the amicus brief MASB just filed? That might be of interest to some
Yes, that would be
folks.
great.
Okay. So there's a case pending in the Sixth Circuit involving a Michigan school district that involves a free speech issue with students. And sure many of you are familiar with the "Let's go Brandon" phrase and what that means. What is that? What's that is code for? And if you're not familiar with it, it means F Joe Biden. Okay, if someone were to say, "Let's go, Brandon," you see that on a billboard or see that on a bumper sticker or sweatshirt, that's what that phrase is usually interpreted as. Um, Students in this school district decided to wear their sweatshirts to school with that phrase. And the school district in this case said, no, we're going to draw the line. Even though the sweatshirts don't actually use those words, we know what those mean. And based on the Fraser versus Bethel School District case, we can regulate vulgar speech in our school buildings. And they decided to restrict that. And the parents in that situation challenged the decision of the district requiring the students to take off their sweatshirts and the claim of First Amendment free speech violation. Case went to the district court, and the federal district court, Western Michigan, sided with the school district, saying that even though the shirts don't say that, it's interpreted to be vulgar speech. We're going to allow the school districts to restrict those sweatshirts from being worn in the district. Now the case is pending before the U.S. Sixth Circuit Court of Appeals. MASB has filed a friend of the court brief in the case. This went through MASB's Legal Trust Fund and was approved by the MASB Legal Trust Fund, was filed a couple of weeks ago. My colleague Dan Feinberg wrote the brief, and essentially we're trying to preserve the management rights of school districts to restrict vulgar speech within the school environment. Even if it's coded vulgar speech, it's still vulgar speech. And the plaintiffs in the case tried to make the argument, well, this is political speech. There should be more protection given to it, but the district court didn't agree with that. So that may be the big decision that the Sixth Circuit was kind of faced with. Is this political speech making it having more protection, or is it just plainly vulgar speech that a school district can restrict? So I have some folks here from the Legal Trust Fund Board of Trustees. I see Stan and Mark, and we had great discussion on that case before approving it. And the Legal Trust Fund felt it was an important case for MASB and the Legal Trust Fund to support. So keep an eye out for that case. May receive a decision within the next 12 months or so.
Yeah, I find that case just because, I don't like to see any district having to go through that kind of legal process. But having a case and it's not about partisanship at all, but just having a case like that on free speech tied to a Michigan school district, at least from kind of the political person that is me, is just fascinated and I want to see what it does going all the way up to the Supreme Court. And I'm sure if I was going to talk to Jill Fennessy, who's on our board of directors and on the Tri-County board, she may not feel that it's a great experience, but I just think it's a really good case that will definitely have a kind of precedent setting over the years going forward.
Yeah, it kind of falls in between two Supreme Court cases. The Tinker case, where you have to show disruption based upon the speech, and the Fraser case where you could regulate vulgar speech. Now, there wasn't any disruption, for the students wearing the sweatshirts. Some kids might have been mildly amused by it. Some teachers may have been kind of uncomfortable with the sweatshirts, but no serious disruption. But still, is it vulgar speech, even though it doesn't include the vulgar F word that it is code for? So yeah, it will be an interesting decision.
Brenda, I did see one question Kurt threw out there. What are you hearing on budgets from the Senate and House?
Oh, that's a really good question. Right now we're looking at, they are planning to pass a per pupil, a foundation allowance, but we don't have anything confirmed other than that. What we are hearing is that they intend to get everything done in the next week, and the House plans to go on a 3-week recess. We haven't heard anything out of the Senate. We don't know what's coming from there, and we don't know what's coming from the governor's office. But I can tell you that they have agreed to a foundation allowance, but we don't know anything else about 31A or any of those other line items. We're still waiting to hear on that.
We're at about 10 to 1 other topics. Brenda, anything else at the Capitol that you think it would be of use for them to know that's going on right now?
There are a lot of bills that are moving as far as the school ed from the Republicans. We haven't had a lot of outreach to you just simply because they're moving so quickly. So they'll be read in and announced in the House. They immediately go to committee, they're passed out, and usually have a vote within 2 weeks. So they're at third reading within 2 weeks before we can even get the information to you. As this moves along, we'll try and share as much as we can with you, but there hasn't been a lot of time for feedback or being able to reach out to membership to get your feedback as to what you would like to see happen.
Just process wise on that, Brenda makes a good point. And I had somebody send me an email last week about one of the House Republican bills that has to do with having a local certificate for teachers that moved out of the House like a week ago. MASB's process in this, if we don't have a resolution that speaks to a piece of legislation, and I would say 3/4 of the legislation that moves, we don't have a resolution on. If we don't have a resolution on it, we have to run that at a minimum through our board of directors, if not our government relations committee and board of directors. And so it takes time to do that. So if the House is moving things quickly through the process, it is difficult for us to move that quickly because it is not Brenda and Jen and I that are like, oh, let's take this position and let's move it forward. We're coming back to board members to take those positions. I know some of you actually sit on those committees. So I know we had a board meeting last Friday. And actually some of the House package, Jen updated us on it, but I don't think many of the House package were even on that just because of timing. And luckily in this case, because of our partisan split between the House and Senate, we're not expecting quick action in the Senate on anything. So it gives us the time to do this. If we had a situation, which we've had in past years where, like last term even, where the House and Senate were of the same party, then we might move quickly to an executive committee of the board because we hear this bill is going to go House and Senate and move within a month. We would do that. But right now, we're just sticking with our normal process. We're going to run it through government relations. They're going to make a recommendation to the board. And what that allows is 40 or so board members from around the state between those two committees and the board to look at the bills and give us guidance. And so it does slow down the process, but it really, I think, makes the positions we take more from the members rather than just MASB trying to be in a place on its own. Because some of the stuff it's not clear where even we think that you will land. So we want that kind of feedback. So that's why it's also that something that slows things down. You're not seeing an alert to support or oppose because it takes time.
Also, just so you know, we have had pushback too from the representatives who are sponsoring these bills because they want our feedback and they want our support. And we've had to explain to them that this, again, as Don said, it's not me and Jennifer making these decisions. We have a process and we are a membership-driven organization. So if we don't get the feedback from you, we don't take a position. So they are well aware of the problems that moving these bills this quickly are causing.
And that doesn't mean Jen and Brenda are still sitting in meetings with legislators and they're giving them feedback. I mean, they've been around long enough to know generally where our members likely are going to land or where there's pain points. But those are going to be in private meetings where we're helping them say, yeah, this is not going to work. We know that from our members. So it doesn't pull us out of the process. It just doesn't allow us to sit in front of a committee typically and say, we are supportive or we are opposed. Sometimes they'll testify about concerns in a bill without actually saying that there's a position. So they're involved, they're engaged, nothing's getting by them that we're not having conversations with. We just may not have the formal position developed quickly enough because the things are moving very fast through one chamber or the other. Any closing questions from you as members? Closing comments from Brad or Brenda?
I guess I'll just remind everyone about the ISD elections. If you're in a intermediate school district where they're having a June 2nd ISD election, be sure that you comply with the appropriate timelines on considering your resolution for designating your representative and also identifying the individual who the representative is going to vote for, and then passing that resolution no earlier than May 12th, and then the filing deadline for ISD elections is May 5th. So you should not be considering that resolution any earlier than May 5th. So make sure you have your meetings in order to ensure that you can legally participate in your ISD election. So you're able to consider and approve that resolution within the appropriate timeframes.
Thanks for that, Brad. And Barb, I don't know if we want to alienate any of our members by taking sides in the MSU U of M battle. I already risked that with my Packer lamp. So, well,
it's too bad they're in the same region. Yeah, would have liked to seen them in different regions, but they may be playing to see who goes to the Final Four.
That would be accurate.
Yeah.
And even Brad and I would disagree on who we want to win between MSU and U of M. So I don't want to risk that because I know you all listen to Brad more than me. So we won't share our teams.
Yeah.
But thank you all for being here today. Really appreciate your engagement with MASB. You can always send questions to us at any time, to any of us, and we'll get back to you. Just appreciate you taking the time to do this with us. So have a great week and enjoy your basketball this weekend.